Okay, if you're heading to the bar, you need to be ready for this. You're going to face meritless litigation, and your ability to shut it down quickly is, well, it's everything. So today, we're unpacking the single most powerful tool you have for that job, Section 31A of the Federal Court of Australia Act. Just picture it. Your client is stuck in a lawsuit that is going absolutely nowhere. They're bleeding money, they're stressed out, and you know the case is a dud, but the idea of a full-blown trial is just terrifying for them. This isn't a hypothetical. You will face this. So what's your opening gambit? Because that first move can make all the difference. All right, here's our roadmap. We'll start with the problem, the hopeless case. Then we'll get into your weapon of choice, Section 31A and its core principles. We're going to tackle the tricky fact versus law dilemma, see how 31A stacks up against other rules, and wrap it all up with the final judgment.
So, first things first, let's really frame the problem here. I mean, why do we even have a tool like summary judgment in the first place?
Because these baseless lawsuits, they're just a total drain. For your client, it's a nightmare of costs and anxiety. And for the justice system, it's like a massive traffic jam, clogging up the courts and making everyone with a legitimate case wait even longer. The system absolutely needs a gatekeeper. And that gatekeeper, the bouncer at the door of the federal court, is Section 31A. Seriously, think of this as your go-to weapon for protecting your client and, frankly, the whole court process. So what is this thing really? Well, Section 31A gives the court the power, a clear statutory mandate to just end a case early. It's the court's green light to say, nope, this isn't going any further, and to do it efficiently, saving everyone the pain and cost of a full trial. Okay, pens out, highlighters ready? This is it. This is the phrase from subsection 1 that you need to have tattooed on your brain for the exams. No reasonable prospect of successfully prosecuting the proceeding. That's Section 31A, subsection 1. That is the hurdle the other side has to clear, and if they can't, their case is done. But wait, it gets even better. And this part, this is the real game changer. It's in Section 31A, subsection 3. The Act specifically says the case does not need to be hopeless or bound to fail. Let me say that again. Section 31A, subsection 3. This was a massive shift. It lowered the bar from the old days, making summary judgment a much more realistic and powerful option for you.
So, we've got the test, but knowing the magic words is one thing, right? Understanding how a judge actually applies them is something else entirely. So let's dig into the core principles that guide a judge's thinking here.
The go-to case here is Dan Devin, and really it all boils down to one theme: judicial caution. Judges are super careful. They're not just going to predict who'll win. If there's a chance that some evidence could come to light and, give color to the story, change the whole picture, they'll let it go to trial. If there's any real dispute about the facts or the law, it's probably heading to trial. And the benefit of the doubt? It always goes to the person trying to keep their case alive. So who has to do what? Well, if you're the one applying for summary judgment, the ball's in your court first. The onus is on you. You have to make the case. But, and this is so important, your opponent can't just sit there, shrug, and say, "Nuh-uh." They have to actually point to a real, tangible dispute. They need to show the court there's something worth fighting about. Vague denials just won't cut it. All right, let's get into some of the trickier stuff. The way a court handles a Section 31A application can really change depending on what the fight is actually about. Is it the facts or is it the law? First up, facts. And the rule of thumb here is pretty simple. If there's a genuine argument over a key fact, your summary judgment application is probably dead in the water. Courts just do not like to weigh evidence or decide who's more believable without a proper trial. So think of a real factual dispute as kryptonite for a Section 31A motion. But what if everyone agrees on what happened, but they disagree on what the law says? Now we get to a really interesting debate from the case of Jefferson Ford. You basically had two camps. On one side, you had Justices Finkelstein and Rares saying, look, a judge has discretion. They don't have to decide really tough legal questions on the fly. But on the other side, Justice Gordon argued that, hey, if the facts are clear, the court can and should sort out the law right then and there. So, who won that fight? Well, the full court in Kowalski gave us the answer. They sided with the discretionary approach. A judge is not obligated to decide a hairy, complex legal question in a summary hearing, and that is a huge strategic nugget for you. If the law is genuinely up in the air, you can argue it's a matter that deserves a full trial. All right, so Section 31A is your shiny new hammer, but it's not the only tool in the box. And for the bar exams, you've absolutely got to know when to use which tool.
Let's do the big showdown. Section 31A versus Rule 16.21 of the Federal Court Rules. The easiest way to remember this? Form versus substance. Rule 16.21 is all about the form of the legal documents. It's like saying, hey, you filled out the paperwork wrong. But Section 31A attacks the substance of the case itself. It's saying your whole argument is flawed. The critical difference? With Section 31A, you can bring in evidence. Rule 16.21 is basically stuck with what's on the page. So if your problem is the evidence, you need 31A. If it's just the pleadings, it's 1621.
And just quickly, let's not forget Rule 26.01. This one is for cases that are frivolous, vexatious, or just an abuse of the court's time. You'll often see lawyers bring an application under both Section 31A and Rule 26.01. They're like a 1-2 punch for knocking out a case that's both meritless and an abusive process. All right, home stretch. Let's boil this all down to the stuff you absolutely, positively have to walk away with.
So let's lock it in. When you think of stopping a meritless case dead in its tracks, I want you to think of this. One powerful tool. Section 31A is your go-to.
Okay, this is your bar exam cheat sheet. Screenshot this in your brain. Number 1, the test is no reasonable prospect of success. Number 2, remember Section 31A, subsection 3. The case does not have to be hopeless. 3, courts are super cautious with disputed facts. 4, they have discretion on disputed law. And 5, Section 31A is for substance. Rule 1621 is for form. Got it?
And I'll leave you with this thought. Section 31A is an incredible shield for justice, for protecting clients from nonsense. But where do you draw the line? How do you balance being efficient with making sure everyone gets a fair shot? That tension between efficiency and a person's right to be heard is at the very heart of being a barrister, and it's something you'll be navigating for your entire career.